My name is Dan Couvrette. I'm the publisher of Divorce Magazine, and I want to welcome you to this Divorce School seminar. It is my pleasure to be talking with family lawyer Robert Stevens today about the 10 things you need to know about divorce. Bob Stevens is the co-founder of the Hilton Head Island, South Carolina family law firm of Clark & Stevens, PA, and with over 30 years of experience in the practice of matrimonial and family law. Bob is a fellow of the American Academy of Matrimonial Lawyers, the most prestigious family law association in the United States. He is the president-elect of the American Academy's South Carolina chapter. He's a certified American Academy matrimonial law arbitrator and a certified family law mediator. To say the least, Bob is very well trained and very well suited to help you if you're going through a divorce in the Hilton Head and Hilton Head Island, South Carolina area. Today we're going to be talking about, as I mentioned, the 10 things you need to know about the divorce process. So Bob, let's get started.
Great. Thank you so much, Dan.
So Divorce Magazine, we conducted a poll recently in which many people told us that it took them more than 10 years to file for their divorce after they had first started seriously considering it. Many explained that they took this long because they didn't want to hurt the kids or that they stayed for the kids. Would you say that this is the best strategy, to wait until the kids have left home, or should you file for divorce as soon as the thought is really, prevalent in your mind?
Dan, it's a very common question, and I really think that it becomes a case-by-case review for the individual, because I certainly understand and appreciate we don't want to upset the children and we're simply going to wait. But I think that there are a couple of things that have to be kept in mind and looked at. One is it a situation where there is domestic violence or emotional abuse in the home that is simply not a good, healthy environment for the children? And on a similar vein, the research suggests that the marital relationship seen by the children has a significant impact on their own future. And so while it may be a common thought, and let's wait, are you showing them an example of a couple that really can have a tremendous impact on them, because this is what they may see as the norm? So I don't think that the old standard of the maximum of the parents should stay together for the children really applies in every case. It's overbroad, and really many of these factors that you have to look at. As with any domestic matter, it's a case-by-case review for the person, for the couple.
And when people come to you and they're contemplating a divorce and they're not sure they're ready to move forward, do you often recommend that they seek counseling before they make that final decision?
In many a case, and in some ways I'll describe it half humorously as I'm not making a recommendation for 30 years of Woody Allen type of analysis. But there are professionals, whether it's a social worker, whether it's a child clinical psychologist, these professionals have a lot of experience in family dynamics, and they can help with looking at the question, how to address it with the children, how the children may be impacted. And it's like anything else, it's just getting the tools to do it as easily as this very difficult situation might allow.
So let's assume that people have decided to go through a divorce. Social media, as you know, is very prevalent. Do you recommend that people post details about their divorce on their Facebook page or other places on the Internet?
I cringe. We cringe at this concept. And I think that whether it is a social media context, whether it is Twitter, whether it is an email, my first reaction is no, please no. And the second reaction would be for things like an email. Step back before you hit send. How is this going to look to a judge later if it shows up in the other spouse's motion papers. How is that going to look to a guardian ad litem representing the interests of the children? And so my immediate reaction is no, don't post it. I've had people who have posted a change in their status from divorced to single and making hundreds of thousands of dollars than they really are on their social media pages. They're just outright fabricating, and it comes back to bite you. Don't
and also
do it.
could bite you if it was shown to your children. If you wrote something horrendous to your ex-spouse or soon-to-be ex-spouse, and they showed that to your children, it would create a whole amount of upset for them, wouldn't it?
Absolutely. And I really try to encourage parents to put their children first, and to the extent it is possible, while still being a well-prepared adversary if something has to proceed to litigation, but to put the children first, because the harm to them between the bickering and the name-calling really both can backfire on the parent doing that and can have such long-term negative impact for the children.
Bob, you've been at this for 30 years. In your experience, can divorce ever be civilized? Can it be an amicable experience? And what can make it turn ugly if it's not amicable?
The answer to the first part is absolutely it can be amicable, and to the extent it makes sense in a given case, I really try to foster as much communication between the parents as is still, or the parties, as is still possible. Most conflicts today are resolved amicably. It can be on the courthouse steps awaiting trial or on the eve of trial, but that's really the goal, because the couple can work out a much better agreement, much better fine-tuned to them than if some judge is making decisions for them. So, yes, it can be done amicably. What can make it ugly? Somebody discovering that monies have gone missing, and the trust issue, whether it's financial, whether somebody gets into a new relationship sooner than the other spouse, and that person is happy while one is not. Any of these can contribute to difficult or protracted litigation, but absolutely, and the goal is, can we get this resolved?
So your experience, what are the main issues that people are fighting about and disagreeing about as they go through their divorce? Is there 2 or 3 or 4 main items?
I think certainly financial. Both parties are going to be concerned for their future and what is to be derived out of a division of assets. Related to that is, has somebody brought a disproportionate share of the assets to what is now considered marital? And tracing those assets can be a significant issue. Certainly the children and custody, and related to that, access to parenting time. And related to that is the label. Is it sole custody? Is it a shared custodial arrangement of some nature? And I think third, and related to the financial side, are inheritance issues. Has somebody received a significant inheritance, and rather than keep it separate, it has now become part of the house or a business? And do they seek to trace that gift or inheritance and say to the court, I should have a greater share of the division because of that gift or inheritance? So these are part of the complex issues that we will see on a recurring basis.
And what do you mean by tracing the asset? What does that mean?
Our role in a more complex financial division is, if, let's say, in a given jurisdiction, the court comes in with a 50-50 division headset, but somebody comes in and says, I sold my house from before our marriage and contributed that to our present house. Well, the burden is on that person to show that premarital or separate contribution, whether it's an inheritance, whether it's a gift. And so looking at each party's contribution to a particular asset becomes the person seeking to prove that. And we will often involve a forensic accountant. We might have business valuation experts involved to help with that analysis and being able to present to the court, here are the assets, here's our theory on how they should be divided and how any marital obligation should be apportioned.
And for those people who are listening to this session and they don't live in South Carolina, or no matter where you live, you should talk with a family lawyer about what the rules are regarding the division of assets and how they're appropriated, because they can change from state to state. Would that be a fair assessment?
No, that's exactly right. And every state makes its own domestic laws. I think many of the states, a majority of the states, have a common framework in terms of how they will view assets and whether those assets should be considered as a marital asset or a separate asset. But then the actual practice can vary wildly between courts. And it is very important to speak to someone and get that education on what is our court likely to do. Even if it's I'm meeting with an attorney once, an experienced family law attorney, and then I'm going to sit down with my spouse, at least you have the framework of what a court may or may not do in a given situation as an education for those discussions.
And this leads right into my next question, which is appropriate. What should somebody look for when they're seeking an attorney? And how much should somebody shop around before they actually choose somebody to represent them?
I think part of it is going to be, this is a very difficult, emotionally difficult area, and you have to be comfortable with the person or the firm or the team that you're working with. Is there a timely response to questions? One of the grievances that is a very oft-heard grievance is, I'm not getting responses. And this is an area where you really have to have an attorney or team that can respond. If there's an issue of somebody taking the child or financial assets are likely to go missing. So a timely response to questions, I think clear communications. We're in a field where it may be very normal for us to talk about concepts, the division of assets and custody labels, but are we making that clear to the client or potential client as against somebody coming in and just listening to an hour of war stories and not getting the information that they really need? And last, of course, would be experience in the field of family law. Is it somebody that, and not to denigrate skills, but does a wide variety of law? Do they handle real estate closings, a little criminal, a little family law? Or is it somebody who really focuses in this area, which really has many facets to it, because the practitioner in this field has to be aware of the custody dynamics, the business valuation principles. How does that state deal with the division of assets or setting child support or alimony? So organizations such as the American Academy of Matrimonial Lawyers, with very rigorous standards for admission. Certain states have family court certification processes so that someone has gone through a very rigorous application. They've practiced in the field for a number of years. They have a certain amount of trial experience. These are the kinds of things, to me, to look for when talking with someone and assessing their skills in this field.
And again, for people, depending on what state you're in, the family lawyer may be a certified family law specialist, they may be board certified, or they may have some other designation. So just make sure you ask those questions when you're out looking for a lawyer to represent you. Now, Bob, you're also a mediator and an arbitrator as well as an attorney. Can you first, I guess, briefly explain what mediation and arbitration is and litigation, and what the pros and cons are of each of those?
Yes, absolutely, Dan. A mediator is considered what we refer to as a neutral third party. For instance, another skilled family law attorney that is trying to help the couple reach an agreement. And that mediator is not making decisions for the couple. They are helping to bridge any gaps, whether it's financial, whether it's custody or visitation, to facilitate an agreement. And many jurisdictions now have some path or form of mandatory mediation. Arbitration, on the other hand, is an attorney that is often either selected by the attorneys in the case or by the court in some jurisdictions to sit as a judge and actually make decisions. And the advantage of either route, but let's start with mediation, is that it can be, first of all, has a very high rate of success. Many cases are resolved at the mediation stage. Cost is a factor. To get through that case, you certainly, and mediation, you have to be prepared for it. You have to have everything ready, but it is vastly less expensive mediating a case or even arbitrating a case. What could be a week of trial might be a day and a half of arbitration. It can be much less formal. The introduction of evidence can be faster. It is certainly less nerve-wracking for someone to be in a conference room arbitrating and putting their case before an arbitrator than being in a large open courtroom with all of its formality. One thing that we are attempting to do more of in agreements is to say if there's a dispute later, we'll have a blended mediation arbitration clause for resolution. How the house will be sold, what repairs might be needed. We're going to mediate it. But we're agreeing early on in our agreement that if the mediator can't help us reach an agreement, the mediator will switch hats and make the decision, because at that point the mediator has heard both sides. They've heard what each party believes or feels should be the resolution, and they make the decision. And it's just a way of getting it done without further expensive litigation.
And when it comes to complex divorce cases, does mediation, arbitration, or litigation work best?
I am prejudiced in that it is a mediation or going to arbitration, again, are far less expensive. It's a lot faster. I mean, there are some jurisdictions that to wait for a trial date can take an extraordinarily long period of time. And so to speed this up and say we're going to work with this person to arbitrate can be 2 months from now instead of a year and a half from now. And another distinct advantage of arbitrating as against litigating, by which I think we're really talking about having a case decided by a judge, is that the attorneys can pick the arbitrator instead of the randomness of the judge that the court assigns to our case. So if I have a sophisticated financial matter, I might pick a sophisticated accountant or a family law attorney with lots of experience in that area to arbitrate it. Or if I have a military case or a case that involves military benefits, I might call as my arbitrator a former attorney in the services who has great familiarity with all of the way that a pay stub reads, which can be like a foreign language compared to somebody working at a small business. And a distinct advantage is our ability to tailor who the arbitrator will be and that person's expertise for the particular case.
I want to point out two things, Bob, to our listeners. One is that you're recommending mediation and arbitration, and in actual fact, that would mean that you would probably, as a lawyer, make less on a case than if the case were to go to litigation. And so I want to point that out to the listeners, that you should pay attention to what Bob is saying. Number two is that judges, depending again on the state you're in and the courtroom that you're in, may be far less experienced and far less knowledgeable about family law than the attorneys who are practicing in that courtroom, because they may be appointed or they may have been elected and not have had a family law background. And so when Bob talks about arbitration, he's stating that the people who are going to arbitrate your case are the most experienced people in the field, the most knowledgeable in, and as he mentioned, some of them in specific areas like military issues or complex financial issues or complex child custody issues. Would that sound accurate, Bob?
No, I think it's exactly right, and I think early on there was some resistance among the people that really just litigated cases. We fight. We are going to go in as your gladiators. But I think that has really changed, and you can so better tailor the agreement than any judge can or generally will. And there are some wonderful judges out there who are caring and knowledgeable, and like in any profession, there are some judges who are less so or come from a criminal background and all of a sudden find themselves on the family court bench, and for whom a complex case is very quickly going to make their eyes glaze. And so, again, a distinct advantage in mediation or arbitration is the attorneys can hopefully pick who would be best for that case to help this couple reach an agreement.
When somebody comes in to see a family law attorney, Bob, is there such a thing as bringing too much information when it comes to talking to your attorney?
Well, I will meet with people, Dan, and on a first meeting, I know that I've got someone who's probably maintained wonderful records when the hand cart starts bringing in the banker boxes. In the long run, as someone who litigates, I always, as a generalization, want more. Is there more financial information that helps trace the gift from your Aunt Sadie or the inheritance or how this building was purchased? I think the main exception that comes to mind now is the risk of where that information came from. I don't want to know and be involved with, more significantly, that you have obtained information in violation of state or federal wiretap laws or gaining entry to a computer that is subsequently deemed as an invasion of statutes. And there are ways to get it, but as a generalization, if I've got someone who has those records and I can prove that, I can do a better job on their behalf.
So if somebody is contemplating divorce, but they haven't talked to their spouse about the fact that they want to get a divorce, is there a way that they should plan for the divorce process? Is there things that they should put in place and things they should do?
I think let's talk about the financial side first. I think that there are basics of financial self-defense. What information can you obtain? I mean, if you filed a joint tax return and you've used an accountant, you're entitled to get copies of that, and copies can always be obtained directly from the IRS. If somebody decides, I can't live here and I'm going to move out, which has its own risks, and someone should speak with an attorney first on that, but do books and records and ledgers suddenly go missing? So I would try to, if time allows, to obtain as much information just for your own education and to help the attorney that you work with. And again, with the children, is it appropriate to sit down with a child psychologist? And I know I'm going to have difficulty with my spouse. I know that this is going to be difficult for my children. Help me gain the tools so I can navigate through these difficult emotional periods that you know are going to come. So these are some of the immediate things that come to mind.
And when you talked about children, and there's children in the marriage, what's the best way to make sure that the children are least affected by the divorce?
Communicate, to try to, and sometimes it is extraordinarily difficult if there's an alcohol impairment, if there's a drug impairment or some other mental health, but to really try to keep those children and their needs and their future in the forefront is critically important. We see too many cases where these parents who have loved each other are so angry and so much is taken out on the children in an effort to get back at the other parent, and it's heart-wrenching to see that.
Well, now that you've brought up the subject of anger and perhaps being spiteful towards each other, can couples who are really going through an acrimonious divorce, can they mediate their divorce, or is there the other choice to just slug it out in court?
No, absolutely. And again, historically now, it is a very successful process. And one of the things about mediation conceptually is that the people are not in the same room together. We're not having the two attorneys, the couple, maybe two accountants sitting down in the same room for 8 or 10 or more hours and glowering across the table at each other. I will attend mediations where I may never see my counterpart for the entire day or the other spouse. And it is a dynamic where the mediator is going back and forth between the two rooms and trying to bridge the positions. Here's what your spouse has said on this issue. And it really is an effective process, Dan, because it allows the individual to be open and have the expression, and yet what they say is confidential. The mediator is only going to relay to the other side what the mediator has been authorized to relay. So someone might have a parent with them or a close friend or some other relative for support and not have to be in the same room with somebody who has an addiction issue or there has been a domestic violence issue. And we try to make the setting as safe and secure. It's a confidential process and it is a very effective alternative to slugging it out in court. And again, in many a jurisdiction, it's now a mandatory stage before you're even granted a final trial date.
And in some states and jurisdictions, Bob, is the option that the people are actually in the same room as opposed to in separate rooms when they mediate issues in the divorce case?
I think that the mediator, Dan, will mostly try to structure and control. Some mediators may want to have everybody in the room initially to give an opening statement to discuss how it is a confidential process. If I represent someone where there has been domestic violence or there is just such animus towards the other spouse, I know that's not going to be effective. And I will call that mediator and say, let's dispense with a joint meeting at the beginning. It's just not appropriate here. Now, the flip side of that is a mediation where at some point one of the spouses says, can I sit down with my husband or wife alone? And by all means, if the other one says, yes, let's do that, and they can hash out an agreement, we are certainly going to encourage that discussion. That's the whole purpose that we are there, but it's important to make it as safe and open a process as possible.
So, Bob, we're going to end with the last question, which is probably one of the first questions that many divorcing people will ask you, and that is, how long is my divorce going to take? How long is the divorce process? And I guess, secondly, is there anything I can do to shorten this process?
We have done divorces from start to finish in a couple of days, where the couple have really worked out an agreement or then sit down and work out an agreement, and there are complex cases with many, many properties that have to be valued and businesses that have to be valued. That can take months, if not longer. And some of it is out of our control. We can have everything ready, ask the court for a trial date, and be given a trial date 4 months out, 12 months out, and that becomes a jurisdiction by jurisdiction issue. In terms of how do we shorten this, I think an immediate answer is help your attorney get the information that they need so that they can best represent you, to be prepared well so it is an effective mediation. Here's my theory. Here are my documents to show it. Convince the mediator so the mediator can convince and work with the other attorney and the other party. Maintain communication with your attorney so that we're not scrambling to get information to effectively help and work with that person. Some of the immediate things that come to mind.
I noticed that you took a deep breath before you answered that question, and I'm not a family lawyer. I'm the publisher of Divorce Magazine, but I suspect, and you can tell me if I'm right, that you took a deep breath because the truth is that it really is a lot dependent on the quality of lawyer who you hire, and you won't blow your own horn, but I will for you. I mean, Bob is one of the top family lawyers in South Carolina, if not across the U.S., he has lots and lots of credentials, so I encourage people to hire the best and most experienced family lawyer you can hire. That will help the process be shorter. And the other part is that, as you've said many times through this interview, Bob, your clients have a lot of control in the matter as to how long it's going to take, how much they cooperate, how much they treat it as a business that has to be taken care of and deal with the emotional aspect of it as best they can rather than looking for a battle and
sometimes, Dan, it's extraordinarily difficult because if you're trying to maintain a business or you are a salesperson and you're on the road to keep your company functioning, from which your spouse is looking for a division of that asset or for support, it's extraordinarily difficult if all of a sudden I have discovery requests come in from the other side that really are going to be hundreds of documents by the time it's completed and reams of paper. And we certainly recognize that. And how do we get this information? Can we work directly with your accountants, with your financial advisor, with a child's therapist? What can we do and make it as a team to try to get you through this process that really nobody wants to be involved with any longer than is absolutely necessary?
Bob, I want to thank you for your time today. Really appreciate it. Just to remind people that I've been speaking with Robert Stevens, who's the co-founder of Clark & Stevens, PA, in Hilton Head, South Island, South Carolina. And as I mentioned, Bob has been helping clients resolve their family law issues involving divorce, separation, property division, financial settlements, child guardianship, adoption, wills, and trust funds since 1981. For more information about Bob and his firm, I highly recommend you go to his website. It is Clark and Stevens, STEVENS.com. I also recommend that you check out some of the other seminars that we're offering on the Divorce School. And again, thank you for listening in. I hope this has been valuable. And lastly, check with a family lawyer in your area to get the details about your specific situation, as they are different from state to state and from even province to province if you're listening from Canada. Thank you again, Bob. I greatly appreciate your time.
Dan and you, thank you for your time.